Good afternoon, Advocate Opperman.
Afternoon, Chief Justice.
Maybe I must begin first by disclosing that you and I were colleagues and had a very healthy relationship. You, myself, and your husband, who wasn't your husband yet at the time.
That's correct, Chief Justice. We did pupillage together.
Yes, we did pupillage together, indeed. Right. All right. You hold a BCom degree?
I do.
And LLB?
I do.
Has the BCom degree helped you in any way in terms of attracting commercial work?
I honestly think not.
Not.
No, I don't think it has assisted.
Tell us a bit about your practice. How has it unfolded over the years and how has it prepared you for appointment to the High Court?
Well, I started practicing in 1990 at the Joburg Bar, but prior to that, I was a prosecutor.
For 2 years, isn't it?
It was just over a year. Over a year, I was in the district court. I think I was in the regional court for a month. And I then did pupillage and started practicing. Initially, and up until 94, I did primarily work in the Northern Cape, in Carltonville, inquests, and representing our communities in matters involving public violence, intimidation against the apartheid structures. So that was up until 94. After that, I developed more of a commercial practice to date, and I do a bit of matrimonial work. And that's really, in a nutshell, or not so much of a nutshell.
Yes. Well, just so that I'm not accused of not disclosing enough, I must also place on record that at some stage journalists wrote about me when we needed offices for the Office of the Chief Justice, that all I wanted was a toilet. And your husband went out of his way to write an article rebuking them. So I must place that on record so that I'm not misunderstood as being somehow favorably disposed to you because of your husband. Anyway, and after some time, did your practice grow stronger, and if so, in what areas?
Yes, Chief Justice, in commercial work, a generalist kind of practice. Initially I did I did asset-based financing, litigation, and that just developed in different commercial disputes, arbitrations. Initially I didn't get much junior brief work, but later on, in the late 90s, early 2000s, that changed, and yes, I was conferred silk. I got my letters patent in September of 2014.
Yes. Now, has the distribution of work to women improved somewhat, and if so, since when?
Chief Justice, I don't believe the figures reflect that. If one looks at the composition of the Johannesburg Bar, there's some over 1,000 advocates. 200 of them are silks, and only 10% of them are woman silks. 7% are white silks, and 3% are black silks. I don't think that one can infer from that women have been given the lion's share of the work available.
You'd recall that when we started, I think there was one woman, Silk, who was doing basically unopposed motion. Have women now since been given quality work that empowers them?
I think there are women that are getting quality work. I have found the transition from a senior junior to a junior silk quite challenging. I think there's a number of features that play into this, one of which is that there isn't the more senior silks are staying within the profession, and so they are it's top heavy. So as the younger silks move into the ranks of silk, they have to compete with the more established practices of the senior silks, and quite frankly, I think the the clients prefer to have somebody who's been around for 10 years rather than for a year as a silk. So I think that's the reality that women silks face.
Do you, as women silks, support junior women practitioners?
Yes, I have been quite fortunate to become a member in June of 2013 of a new group which was formed at the Johannesburg Bar, Tulamela, and it was spearheaded by some leaders of our profession, and it is a transformation initiative. And one of the objectives, there's a sliding scale of contributions that's made to, or payments that are made to payment of rental practice expenses. So the more senior you are, the greater your contribution to practice expenses. And the point is to support and assist junior practitioners, including practitioners from historically disadvantaged backgrounds. So one is supporting and paying for practices of these junior practitioners. In addition, we have a junior development fund where senior practitioners would recognize that a matter has interest and the skills can be transferred, and junior members would be drawn in, be introduced to the attorney, and be paid by the group fund for a certain period of time, and in that way. So, and in addition, I have on occasion reduced my fees to draw in juniors of historically disadvantaged backgrounds, and so there are different ways of assisting.
Yes.
Which I must compare to when we started. Group 17 was a group of pupils, and we were all very junior, with very little guidance and assistance. So I think this initiative of Tulamela is a wonderful one, and yes, I think it does go some way,
Yes.
assisting younger practitioners.
Thank you, JP.
Thank you, Chief Justice. Good afternoon, Advocate Opperman.
Good afternoon, Judge.
It's been a long wait.
It has indeed.
Well, it's been a long wait from last year, August, isn't it?
That's correct.
Isn't it?
That's correct.
Yeah. Me and you have been having discussions about you availing yourself.
That is correct.
You confirm that.
That's correct, Judge President.
Right. Now, you've acted for not less than 24 weeks totally in the High Court.
That's good.
And you regard yourself as ready now?
I do.
Well, I must say thanks for availing yourself, and thanks for the efforts of your husband. I know he convened a get-together to try and respond to my call that senior members of the bar were not availing themselves. And in recent times, my roster is full of silks who are prepared to come.
It's a good step now.
Yeah. So, in terms of judgment writing, you've not struggled at all?
Well, I have now acted in 2014, 15, and 16.
Yeah.
And the writing, I don't find problematic. It's, one gets into a rhythm and a structure and a method. But I think when one starts acting, one's particularly cautious and wants to consider every argument and deal with every argument and make it clear that one's considered it properly. And this is time-consuming and perhaps not always necessary. So when I acted initially, I think it was a bit of a vuurdoop. I got 2 opposed motion roles, almost back-to-back. And I had 12 criminal appeals. And it was all a bit daunting. And so I came away with 11 reserved judgments. But thinking, because the chairman of the Bar Council at the time, Pitt Lowe, had sent a circular that it would be considered unprofessional conduct if a judgment was not delivered within a period of 6 months from the date of hearing, that a reasonable time constituted 6 months. For some of them, they fall within the 4 to 6 month period. But since I became aware of my error, and from 2015 and 2016, all my judgments have been delivered within a period of 3 months. In fact, one of my reported judgments was delivered within a period of a week. And I can say the judgments that I referred to, for example, the Makwakwa judgment to be found at page 90, and the Smith judgment. The Makwakwa judgment was delivered on the very day that it was heard, and the Smith judgment 114 was delivered the day after the matter was heard. When it concerns issues of liberty, there is no question that judgments should be delivered there and there.
But other than that, you've had no problems? I've never had occasion to call you and reprimand you for reserve judgment.
No, you have not. You have not. And even those that fall into that period, the litigants didn't ask. They didn't complain. The judgments were delivered. They went out. And in 22 weeks, I've done 42 judgments written. And that's not the extempore judgments.
Yeah. You may not be able to respond to this, but try. As I said, I thank you and those from your ranks, silks, who've availed themselves to come and assist in the High Court. I still struggle to get more black senior practitioners to come. They come, but it's a problem. I'm talking about females. If it's not Leah Gavashe in Johannesburg, then
Ms.
it's
Nkosi Thomas.
or Ms. Nkosi Thomas, although she's avoiding me these days. What's the story? I'm having an oversupply of white male silks who are ready to come. Are they not there, or what's happening? I'm not putting you on the spot. Maybe you can assist in me finding them. Yeah.
Well, my group is
Talk aloud.
Competent. There's so many. Tandi Norman, and you've mentioned Motsa Maroka, Sina Yakub. There's so many competent.
So I should just be patient and look and find them.
I think you should be more persistent.
Persistent. Thank you very much, Chief Justice.
Thank you, JP. MEC.
I'm covered, Honorable Chairperson. Thank you so much.
Thank you very much. Commissioner Helens.
Thank you, CJ. I also have a disclosure to make. Ms. Opperman and I have known each other since she did pupillage. I think she came to court with me during her pupillage.
I did.
And you've been my junior.
I have.
I'd just like to make one point, not really a question. The Tulamela group, for everyone that needs to know, is the leading group at the bar with regard to transformation. Well, it's right up there at the top. There's a cross-subsidization of upliftment process on gender and racial lines, and they are a model. Maybe Issues also a model, but they're right up there. But can you tell us, in a nutshell, what your judicial philosophy is?
One should give, in my view, parties a proper hearing and then deliver a judgment. And the reason for a well-considered judgment within a reasonable time. And the reason for this is that the very basis of our legal system is that we want to prevent self-help parties taking the law into their own hands. So the way in doing that, in my view, is to give the parties a fair hearing where there's an independent adjudicator who demonstrates it. So it's not just a subjective consciousness of this quality, but it must be readily apparent. It must be impartiality, both subjectively and demonstrated. And yes, so a fair hearing, so that the process exhibits that. And then the judgment must be delivered to give clear reasons. There must be clarity in the reasoning process for a number of reasons. But that is because a court is accountable to a number of parties. A court is accountable to the litigants foremost. The court's accountable to the courts of appeal, to this commission. It only speaks through its judgment, and more often than not, a judgment is really directed to the loser. So the reasons must be clear, it must be understood by the parties, and it must come out reasonably quickly.
Then a different question, if you could explain to us what you understand by the concept of separation of powers.
Government consists of the executive, the legislature, and the judiciary. Now, there isn't an absolute separation, but the different arms must be permitted to perform their functions. There must be a respect for the different arms of government, and there's a system of checks and balances contained in the Constitution which will keep the powers on the straight and narrow. And that is what the separation of powers is designed to do.
Thank you, Commissioner Helens. Commissioner Nkosi Thomas.
Thank you, Chief Justice. Good afternoon, Ms. Opperman.
Good afternoon, Commissioner Nkosi Thomas.
Chief Justice, perhaps I should start off by making the declaration that we sit in the same group. So I'm quite chuffed to hear that we are regarded as the most transformed group in the country. Did you say?
I stopped at Joburg.
But thank you. Ms. Opperman, I note that you said now, when you started with the interview, that you did some work as a district court prosecutor and as a regional court prosecutor, but then you came to the bar, and your practice is pretty much of a civil nature, be it commercial or...
Post-1994.
That's right. But then how are you on experience as far as criminal litigation is concerned? Have you acted, first of all, in the criminal court? If not, do you have experience? Do you think that you will handle that aspect of judicial office comfortably?
Yes, I must confess that when asking myself why I want to be a judge, one of the things that became apparent to me whilst hearing matters is that I do have a sensitivity for the vulnerable. And I think that finds its roots in the work I did pre-1994, when I saw the economic oppression, state abuses, and perhaps also from my mother, who was a East German a refugee who came to this country with a standard 6th education and was economically dependent on my father. So I have a sensitivity for the vulnerable. And in selecting the judgments that really spoke to me, or what I wanted to communicate to this commission, I selected 3 of the 5 speak to the justice being dispensed in respect of the vulnerable. And the one is S versus Moyo, dealing with the 7-year-old rape victim, and the other, and then there's Mkwakwa, and then there's Smith, who is a confessed crack addict, but who somehow the system went wrong with him, and it was corrected. But to answer your question, I think I have a solid grounding. I did a lot of appearances under difficult circumstances pre-1994 in the criminal courts.
And as an acting judge.
As counsel, as an acting judge, I have done a considerable body of criminal work.
Well, thank you. And just for the record, JP, I've responded to your request for the acting, or rather to the honor. I've responded to that. So I've made myself available, JP. Thank you, Chief Justice.
I think you must be charged a fee for using this platform to communicate to each other like that. Commissioner Singh?
We'll talk about the fee later, CJ. Good afternoon, good evening, Advocate Opperman. Just 2 questions. One I asked of a candidate earlier on, and I received an answer. Particulars of your community and other organizations of which you are or have been a member in the past 10 years. You put not applicable. Can you just speak to any involvement that you've had with community organizations, etc., in the past 10 years?
I've been a member of the Johannesburg Bar, and there during that time, I've had pupils, I've lectured the law of evidence, I've been involved in advocacy training. I have moved to Tulumela Chambers. Unfortunately, in a marriage, where one's married to another advocate, and we have children. The time is a bit limited to spread it further than that. So perhaps it is not a good reflection.
I think Deputy President Maya would recall when we were on that subcommittee and we heard similar kinds of challenges, Chief Justice, that women have in particular. When we had to make recommendations to this committee. The next question is, can we as a JSC rest assured, because you say that You've appeared occasionally in court. Your court experience is occasional. Can we be rest assured that the 23 or 24 weeks that you have had acting has equipped you sufficiently for us to favorably consider your permanent appointment?
I have 26 years of experience as an advocate. Occasional is now, but I find as a junior advocate, one's in court almost every day, and the more senior you become, the more you work up a matter, and then you go to court. But your court appearances or arbitration appearances aren't that frequent. So I certainly, the skills and the manner to adjudicate evidence and to assess evidence, I think I do have sufficient experience, and in both commercial and in the criminal field.
Thank you, Commissioner Singh. Minister?
Thank you, Chief Justice. To your credit, and just looking at my Braille notes here, there's a note to the effect that she remains a fearless proponent of justice, even to the extent of exposing a judge on circuit who made racist remarks in chambers and in open court. She sought his recusal. Now, one would love to defer to the assumption that members of the judiciary, over 2 decades into democracy, have long rid themselves of the legacy of racial prejudice. Is it a phenomenon that continues to haunt the profession in any significant way, or is it something we can assume is highly isolated? And if it's the former, what is it that we should be doing as a country to confront it head on and deal with it effectively?
Minister, I think as a general proposition, I think it's not something that is common, certainly not something that I have experienced of recent times. But I think everybody has, to a greater or lesser degree, prejudices. And it's because of that, either conscious or subconscious, that it's necessary to have diversity on the bench. Because if you put people together who are all alike, their prejudices would become, they would conclude, but this is, natural, or this is the way things are. Whereas when one puts people together who are not alike, they will interrogate those assumptions, and will actually leads, putting people of diverse backgrounds together leads to a better debating process and to a better ultimate conclusion. So I think for example, in the appeal courts, in assessing probabilities, it is so important to put people of different backgrounds together, because everybody does bring something else, a different perspective to the party, and figuratively, to the process. And so I would hope, and I haven't experienced it personally, I've read about it, of any issues relating to racism. But I think the way to deal with it is to focus on diversity on the bench.
The concern about the exclusion of women and blacks from lucrative legal briefs or legal work, which is perceived as one of, or is actually one of the most severe ways of expressing racism, is a challenge that continue to haunt the profession, in part fueled by clients who still harbor racial prejudice and therefore would not give work to historically disadvantaged practitioners. What kind of interventions, if any, do you believe the state should consider in this regard specifically to try and level the playing field?
Joburg Bar, towards the end of last year, passed a resolution in terms of which it was agreed that in any 3-council team, at least one of those 3 council must be a black council. Now that is it's got Bar is still working on exactly how or the mechanics of it, but that resolution is to be welcomed. It was it came against the backdrop of what happened in the silicosis matter, but that compels briefing patterns to change. What the state can do is perhaps to also get corporates together and make a sanction if black council are not, I don't know, perhaps legislate it even. It's a very difficult topic to address. I think the professions must deal with it from, internally, as the bar has attempted to do quite recently. But what the state can do is quite a challenging one. Sorry, I'm not very helpful.
That's as far as you can go, and I appreciate it. Thank you very much. Thank you, Chief Justice.
Thank you, Minister. Commissioner Semenya.
CJ, thank you. Advocate Opperman, afternoon to you.
Good afternoon, Commissioner.
You come with commendation, and I might add, which is well earned and deserved by very respected members of the profession who think you should do the work of a judge. In your own words, why should South Africa entrust you with the responsibility of presiding as a judge? And I suspect you can.
I do have a compassion for the vulnerable. I do have a strong work ethic. I find it very difficult to promote myself. I'm not entirely sure how to address this, but I think this, I believe I can do the job. It's not a job, it's the highest calling. Yes, there is no higher legal calling. And it would be a great honor to be given this opportunity. So I really don't know why I should be chosen from amongst other competent people, other than I have a passion for it, and I undertake to do it to the best of my ability.
The country will be proud for it. Thank you, Chief Justice.
Thank you, Commissioner Semenya. Commissioner Modise.
Thank you, Chief Justice. Mayor Opperman, good afternoon.
Good afternoon, Commissioner.
The perceptions that the lives of South African women are actually cheaper in the eyes of the courts What do you think of it?
It's completely it's sad that there should be such a perception. It's completely wrong, and so I think it's a sad day for our society that there is such a perception out there that our courts view the woman in our community as anything other than, less worthy.
So you have not come across it. It is just said. You have not done anything about it.
I'm not sure I'm understanding your question correctly. Are you saying that this is the council or members?
No, ma'am. I am saying over the years we have seen sentences being passed down by the different courts in this country, especially when it comes to the rapes of girls and women and the murder of women, and that because of sometimes the ridiculous sentences that are passed, the perception is out there in the streets of South Africa that the women's lives are actually very cheap in the face and in the eyes of the courts in South Africa. You were not aware?
No, I'm aware that there is a controversy in relation to that, and that what I can say from my own experience, and for example, the one matter that I referred to is I consider, rapes of women and children very seriously, and in this S versus Moyo matter, analyzed the tendency to reduce life sentences to something lesser than that, and the tendency to do so, and in respect of yes, so I'm very conscious of that feature, but I think all the cases must be dealt with on their own merit, and but as a general proposition, it is completely unacceptable to operate from the base that the woman their lives are somehow worth less.
Do you understand the Commissioner's question? As I understand, it's basically this. Do courts do enough to deal effectively with serious crimes that affect women, like murder or rape? Am I misrepresenting your question there?
I think our courts are addressing it, and I certainly, in my dealings with matters of this nature, have addressed it. And in this first matter, which appears at page 29, it analysed the tendency to reduce life sentences and concluded that there is no general rule of reducing life sentences, and that, in fact, children victims should be afforded extra protection by our courts. So that was certainly the conclusion I reached in that judgment. So insofar as there is authority out there to a different view, I certainly will not follow it.
I'll leave it at that, CJ. My last question is to take you just back to your response on the separation of powers. And I agree with you, you said that clearly there is no arm that is completely separate from the other. What would you say to the assertion made by the legislative sector that in fact the overreach is often too much directed on the legislative sector rather than between the executive and the judiciary? that in fact the legislative sector never has an overreach into the courts or into the executive, but that the other two seem to have an overreach. Do you have any opinion on that?
You see, I think in respect to the legislature and the court's ability to intervene, I'm not sure that I'm in a position to compare the two interventions, other than to say that the judiciary must be very, very respectful, not timid, but be very cautious of intervening on the other legs.
Thank you, CJ.
Well, as I understand the Commissioner's question, and that's because it's been, I've come across it before, don't you get a sense that, in effect, the executive and the judiciary have relegated Parliament to a junior arm of the state, and they are projecting themselves effectively as the two senior ones?
Chief Justice, it's clear to me what I should be answering, but I'm not in a position to really.
Did you find this environment welcoming or somewhat intimidating?
This environment?
Yes, here.
I found it far more welcoming than I anticipated.
Okay.
Except I was so hyperventilating.
You were?
I was, but that's nothing to do with the commissioners. It's all internal.
I was asking because I didn't see the Ingrid Opperman that I know. Thank you very much. You're excused, ma'am.
Thank you.
Oh, I'm sorry. Aibo, you have helped. You have helped. Thank you very much. Commissioner Nsebesa has a question.
Advocate Opperman, I will not detain you longer now that you were off the hook until the Chief just said, I have a question to ask. There was something that you mentioned earlier on about East Germany, as it then was. What were you indicating?
What was I?
Indicating about you and East Germany. I thought you mentioned something about East Germany.
It's nothing. It's just a fact that my mom's German and that they fled during the Second World War from East Germany to West Germany, really came to West Germany with nothing and then came to South Africa with a standard 6 education. So there was nothing more to it than but I may as well say, she may as well have been from Iceland. It was just a statement of a fact. Yes.
Well, I thought that you were seeking to convey something about inequalities and oppression, given the history of East and West Germany. You were not seeking to do that, were you?
I wasn't going into that other than...
Now, I just want to also ask you about your notions of transformation, especially at the bar. It has been my experience, and I don't know if it has been yours, that when it comes to thought leadership, or when it comes to so-called transfer of skills, most practitioners have been looking at it as it being a transfer of skills from white people, white practitioners, to black practitioners. How has been your experience?
I think certain parts of the profession have people hold on to so tightly, like intellectual property, construction work, and the transfer. And I know there were two recent pilot projects initiated by my husband whilst he was on the Bar Council. And what was clear is that it's that people are being briefed who come through the ranks of the attorneys. So it's certainly not transfer from necessarily from white practitioners to black practitioners, but from a group of practitioners that hold the key to certain areas of law to the practitioners who don't hold the key or access to those parts of the law. And at the moment, I've seen transformation change over the years, and at the moment, I think it's assisting junior practitioners and practitioners from historically disadvantaged backgrounds in building sustainable practices. I think at the junior practitioners in our group that are from historically disadvantaged backgrounds can transfer skills to senior practitioners, but it's really more about building sustainable practices and making access to, or giving them access to attorneys.
Can I ask the question differently? Has it not been the assumption by many that when we talk about transfer of skills, we talk about white practitioners transferring skills to black practitioners?
It has been.
To ask a further question, in your entire practice, have you had an opportunity to invite a black senior to lead you in any of the matters in which you were involved?
I have not had the opportunity.
Were you in a position to ask to be led by a black practitioner? For instance, there must have been cases where you were briefed and you were to choose your own leader. From Semenya, Naleka, to others, to Morrison, to Trengove, and all of those, where you had the opportunity to choose a leader. Have you ever chosen a black silk?
The opportunities have not been many, but I have not chosen black silk.
A number of interviewees today and yesterday were asked about the languages that they have learned, African languages. What is your position relevant to your proficiency in any African language?
I cannot speak an African language.
Do you have a reason?
I don't have a reason.
You see, I'm asking these questions because you are seeking elevation to the bench. And I want to ask you candidly whether part of the shortcomings of a transformative agenda that creates and perpetuates an impression that thought leadership comes from white practitioners. Whether that will not affect you as a person sitting on the bench from inadvertently, and I'm putting it at its lowest, looking at who appears before you and assuming that better arguments will come from the white practitioner. It's a debate.
Commissioner, I must confess that during this entire process and watching these interviews, I have been embarrassed about the fact, or this question. It's been asked a number of times, and more of an effort should be made. I think one is in a comfort zone when one assumes that the language which is being used in the courts is English, and there needn't be nothing further done. But it is unacceptable. And I was actually speaking to somebody outside to say something needs to be done. We need to learn another language. I'm just not sure at the age of my age whether it's going to how quickly that will happen.
I'm not even addressing language only, Ms. Opperman, at this stage. I'm just addressing the entire question of it being an assumption. And that's why I asked the first question. There is an assumption that you can only get transfer of skills from white practitioners to black practitioners. That if there is any thought leadership about law, you are more likely to get sound legal arguments from white practitioners and not from black practitioners. That is why I therefore said, I'm asking the question because if we recommend you and we don't know what your view is, the likelihood, and I'm putting it at its lowest and its kindest, the likelihood might well be that when you sit as a judge and there are practitioners, one black and one white, your knee-jerk reaction may well be that you are likely to get sound arguments from the white practitioner. And this is a function of growing up in an environment and a society which assumed that thought leaders are white practitioners and black practitioners are followers. And I say so in light of also the resolution of the Johannesburg Bar that talked about a 3-counsel rule, where the assumption was that it is inappropriate in a matter where 3 counsel are employed for them not to be diverse. The assumption was that if you would have 2 whites and then the third person would be a black person. It has never been my view that we all assume that you could have a black leader, a Semenya, leading an Opperman and somebody else. Has that been your experience as well?
Well, I can't speak about the perceptions of others. I can say that I do not view any black counsel appearing before me as more or less inferior to the white counsel opponent. I listen to the content of the argument, I read the heads of argument beforehand, and I know as a fact there's a formidable black counsel out there. And I don't know. I can only speak to it from a personal level. So I would hope that I would not have such a bias. And I know as a fact that when I get a matter, I read the papers, I read the heads, I listen to the argument, I try and distill what I understand the argument to be, and I do not believe that I afford one party or assume that I'd get a better argument from the other one party rather than the other.
Except that you don't seem to be able to explain why it was business as usual that all your leaders have been anything but black leaders in your entire practice.
I was in groups where there were very few black silks. I was in Maisels. I think it's Rafiq Bana. So in that group I was for many, many years, more than 10 years. And one tends to get either drawn in or draw people in from your group. I moved across to a different group when I was recommended for silk. So at a time when I was not drawing in silks, but leading matters. So my circumstances were such that I wasn't exposed to many black silks, and I wish I had been drawn in.
In Tulamela, you have leading silks who are black. Have you ever invited them to lead you?
Because I have attempted to do the leading myself. I was a silk, or I was recommended for silk. So that's been my trajectory. But it's not just because of an inherent bias. Circumstance-driven, I changed groups, and yes.
Chief Justice, I won't take it any further. It's a debate we could have with Advocate Opperman, but for now it is okay.
I think he's exploring something that I picked up not so long ago, unconscious bias. You don't know that you have bias and therefore you've got no problem to solve.
Yes.
Could it be that you need to look deeper into that? I've picked up instances of unconscious bias about myself in other areas.
Absolutely, and it's for that reason that I mentioned the example of the diversity, and that one must interrogate these issues, because one must. Yes, I do agree wholeheartedly.
Okay, Commissioner Malema.
How do people become racist?
I'm not sure there's a bias, prejudice. I'm not sure how it becomes, but yes.
How do they become racist? Are they born racist, or they go through some form of upbringing, or their culture requires of them? How do they become racist?
I think it's taught, and it's it's a taught, and it's a superiority thing, but I don't think children are racist, so I think it's a taught bias, a taught thing.
Don't think you were taught bias?
No.
You don't think you were taught to be racist?
I think children follow example.
No, we're talking you now. You are never taught to be a racist.
I grew up under the apartheid state, so I was I grew up in I was taught in a government school where, it was segregation, and so there was lots of propaganda. So, yes.
So you were taught to be a racist?
Yes.
So you are a racist?
I think as an adult, I had insight into the wrongs that I was taught, and I have, in the work that I did and the insight that I gained through the work that I did pre-1994 in our communities, in Hopetown, where I saw economic oppression, in the matters where children were killed by police, by the excesses of police violence, and done the inquests with Dr. Klepp, who was a pathologist, is a pathologist who worked under Dr. Gluckman. As I realized the error of the ways. So as an adult, I had insight into this, and I still am conscious of those scars, and that I must not bring that to bear on my judgments that I make.
Remember, the first step of dealing with a problem is to admit that I've got a problem. You ought to admit that you are a racist in order to deal with that racism out of the consciousness you developed through whatever engagements you had during those times. So can we agree that you are a racist? Because you were taught racism.
I've distanced myself from those teachings. I've, as an adult, appreciated that those teachings were wrong. I've conducted myself in a manner which is different to that, and I object to being called a racist.
We are with MEC of Education here who said to some professor or advocate, this person, the first qualification he got was teaching, and now he's a professor at that level, as it were. And he was still reminded that, by the way, you are a teacher, and happy World Teachers' Day. Because he was taught to be a teacher, he was qualified to be a teacher. That's what he was taught. And whether he's a professor, he's an advocate, that which he was taught he is that thing. Now, the point I'm canvassing is that you, in answering your question there of why are you not speaking any African language, your answer was, I don't know. And that might be a subconsciousness which borders on racism, that you have never seen any need to learn other people's languages because they are so inferior and not so important. And that's why you can even still give an answer here, I don't know why I can't speak these other languages. Because that's superiority. That's my observation. Am I correct to say you are suffering from white supremacy? That's why you don't know why you don't know African languages. They are not important. Because mine is superior. I am superior. It comes out, that problem of white supremacy, because even if you try to suppress it, you were taught that you are superior.
Commissioner, I thought she responded. Do you want to respond?
I don't want to respond, Chief Justice.
What was the response, Chief CJ?
I understood her response to be, I grew up in that environment. There was propaganda channeling us in the direction of racism. I became a grown-up and decided to distance myself from racism. That's how I understood her. She worked herself out of racism. Commissioners are here to correct me if I'm mistaken. I thought that was an answer to exactly what you put into her. Thank you very much, Ms. Opperman. You're excused.